Good afternoon, everyone. Today is Friday, August 26th. I wanted to update everyone on the pretrial hearings that occurred yesterday. We got out of court fairly early yesterday, but a lot was accomplished. I would say that yesterday was a day for the defense and not so much for the prosecutors. I found a video online to help you guys remember one individual from the protester is no longer with us to defend himself in court, and that's Lavoy Finicum. And in this picture here, we see him standing up facing the reporters. And in the right corner of our screen is Pete Santilli, the only press that is in court right now facing charges. All this press you see in this photo, none of them were prosecuted. But so let's get on with the case. I will share with you the notes that I have. The judge had another hearing yesterday morning to attend to, so she was late arriving. Ammon's attorney was also late arriving to the court. He was reprimanded by the judge. I think the judge forgot that she too was predisposed and was running late herself. Pete Santilli made the best of his time while we're all sitting waiting for the judge. He noticed that his nameplate, which is paper and it's laminated, it was not staying upright yesterday. And he leaned over and commented to David's attorney, he thinks it needed Viagra. It has to stay up for at least 4 hours. David's attorney nodded his head in agreement with Pete while both of them laughing at the joke. Jeff Banta's attorney was present in the courtroom this morning, but Jeff was not there. Medlock also waived his right to appear today, but his attorney was present in the courtroom also. Oh, and I made a video yesterday telling you guys about the ties that the prosecution wore. Well, ironically, the prosecution table today looked like a bunch of clowns. From right to left, one wore a medium solid turquoise tie. The prosecution sitting in the center of the table wore a polka dot tie, and the one at the left end of the table was wearing a striped tie. It was actually pretty comical compared to yesterday's choice of the golden power ties that they wore. So court began by Shauna Cox giving notice to Judge Brown that the Ninth Circuit Court has accepted her appeal. Shauna put the judge on notice that to proceed with the case would be on the judge's own accord. Judge Brown replied, "I don't know what you mean," and the hearing moved forward without either side elaborating. David Fry's attorney asked for a Dahlberg hearing concerning expert testimony of his client's condition, which is a schizophrenia type of personality that explains many comments David made during the standoff, which eventually led to his surrender. The Dahlberg challenge is a hearing conducted before the judge where the validity and admissibility of expert testimony is challenged by opposing counsel. The expert is required to demonstrate that his or her methodology and reasoning are scientifically valid and can be applied to the facts of the case. The term comes from a 1993 U.S. Supreme Court case of Dahlberg versus Merrill Dow Pharmaceuticals Incorporated, 509 U.S. 579, 1993, which the court articulated a new set of criteria for the admissibility of scientific expert testimony. In its 1993 Kumho Tire versus Carmichael opinion, the court extended Dahlberg's general holding to include non-scientific expert testimony. Prosecution objected based on Rule 704, which made the testimony inadmissible. However, the judge ordered that the oral arguments on the objections and the Daubert analysis would take place next week. Pete Santilli's attorney said that Pete would like to attend those hearings, and the judge agreed with that. The next issue addressed was the prosecution's desire to quash the subpoena requiring Governor Brown to testify in the case. Ryan and Ammon subpoenaed the governor and wished to examine her over the comments she made during the occupation. Prosecution objected, citing the Morgan Doctrine, and claimed that it was not necessary for the governor to be called to testify over an article written by the Oregonian, claiming that it was a waste of the governor's time. Excuse me, guys. Attorney for Ryan Bundy argued that the governor played a leading role in ending the occupation and the policy decisions made in her official capacity as governor. Ryan produced letters from the governor's office, one addressed to Judge Grasty and the other letter was addressed to President Obama. He also produced a calendar associated with policy concerning ending the occupation. Defendants also claimed that the governor made comments concerning the financial burden on the state as a result of the occupation. No one would be able to testify about these things except Governor Brown without running into objections over the hearsay rule. Assisting counsel for Ryan Bundy explained once again, these letters, communications between the governor and Judge Grasty and the president, the policy and timeline determined for the occupation are only things the governor can explain to the jury. The Morgan Doctrine does not apply in this case because Governor Brown was directly involved in this case and in her official capacity. Judge Brown received copies of the documents from Ryan and needed time to consider the arguments and evidence on both sides. My opinion, though not a legal one, is that the governor's testimony is necessary. She played a crucial role and also kept in communication with those such as Judge Grasty and other higher-up federal officials. So the next issue discussed was Shauna Cox's expert testimony from an accountant and financial specialist that would dispute the government's claims of damages. The judge ruled that the prosecution would not be bringing that matter up in court during the trial. But if the defendants would be found guilty, then the matter of restitution would be addressed. And if that happens, that would be the appropriate time to discuss the testimony of her expert witness. According to the judge, during these court proceedings, no one will be allowed to specify a dollar amount of damages, just that there was damages, specifically to a camera and an automobile that was stolen. The next issue prosecution raised was 1072 motion to provide video conferencing to, quote, victims at the BLM facility so they could view the trial. No objection was raised by any of the defendant's attorneys, which this really shocked me. The judge stated that the stipulation would be the same, that there would be no recording of the conference that could be made if this was to happen. It was shocking to me that none of the defense attorneys had an issue with calling BLM employees victims and allowing a request for video conferencing based on victims' rights. The charges against the defendants of impeding federal employees have not been proven, nor has it been proven that they were under any threat or intimidation by the defendants. So how these people could be labeled victims, I have no idea. Now, if they're found guilty and wish to face them afterwards to give a statement on record, I could see how that would be fair. But to label an entire group of BLM employees as victims and give them preferential treatment prior to the trial even starting is unacceptable in my opinion. And it's my hope that one of the defense attorneys will argue against it, because I believe it'll paint a picture for the jury that everybody agrees that these are the victims, and I currently don't see it. Maybe I'm wrong. But I'm not a legal expert. I just my own personal opinion. The next issue discussed by the judge was the need for the prosecution to create a list of exhibits that have been pre-approved and a list of witnesses. The judge also noted that any exhibit that was pre-approved and on this list would be allowed to be used during opening statements. If it's not on the list, you don't get to use it. The judge also mentioned the need for the jury to have a binder to organize all their notes and information pertaining to each defendant. She mentioned this yesterday, but once again, neither side commented on the issue. The judge also mentioned that she was fully aware of the jury nullification issue that's being discussed in venues right now. She's aware that flyers will be passed out across the street from the courthouse and will ask the juries if they received one. Physical instructions about the principle of nullification should also be in the notebook for the jury to review. And the final issue I listened to before having a break was brought up by Pete's attorney, Tom Cohen. The issue was about the prosecution's need to provide specific evidence proving there was a conspiracy, such as described in Noto versus U.S., as well as two other cases stemming from the 1960s. The issue brought up in those cases is very profound for the defendant. There's a term called stricti juris, and according to or determined by strict interpretation of the law, the strictest. Okay, so yesterday they were talking about these comments that were made on Facebook and stuff like that. They're not specific comments that say, hey, let's go impede federal officers. But the prosecution wants to use them to show that there was a plan in place in November and December to do that, even though the wording doesn't say that. So, in other words, it's like these articles from the Review Journal, the Oregonian. They're calling these patriots anti-government, militia, all of these terms that would incite people to believe that they're against the government. Okay? Even if they have anti-government beliefs, their actions have to show that they were trying to overthrow the government. Their actions and specific words. So the guys in this case are being charged with impeding federal officials and conspiring to do so. So their words would have to be very specific. Hey, let's go impede these federal officials. Let's prevent them from doing their job. And the comments that the prosecution has taken off of Facebook, they don't prove that at all. But according to these cases and the standard used in these cases from the 1960 against Communist Party, the government's going to have to come up with some very specific comments these guys made to prove there was some type of conspiracy to impede these federal officers through threat and intimidation. The prosecution didn't seem too happy about Tom Cohen's introduction of the stricta juris principle, but I could see the importance of it. When someone is planning or conspiring against government employees from performing their duties, especially in light of the facts of the case. The higher-ups in the government told the employees not to go to work, and that prosecution seems to have cherry-picked through Facebook comments and emails to find tidbits that allude to a conspiracy being in the works since November 2015. And because the defendants were unhappy about policies and laws that were harming ranching families, they were and still are being labeled anti-government militia members, among other names. The prosecution being required to present evidence specific to a plan or conspiracy being carried out is going to be more difficult because in most cases they're relying on the general statements made by a few just to convict everybody. Hearing ended early and we're not expected to resume until next Wednesday. I will not be attending the hearings next week because I'm returning home on the 1st of September. If you're in the area or planning a trip and can attend some of these hearings, please share your information with us. I don't know about others, but the speculation about how things are going, how these patriots are doing also, the speculation's not important. I'd rather know the specifics so I can form an opinion of my own. I know that the people in the social media community are talking about the case and the people involved, but they're sharing second and third hand information, and therefore they're not factual reports. So, especially being labeled the truth community, you don't know the truth. You're talking about shit that you heard from someone who heard it from someone else. But if you're not there, and I know you're not because I am, if you're not there and you're reporting on this information, it's gossip. It's not factual reports. It's gossip. Even if it's posted on a Facebook page, it's still gossip. So that's all I have, guys. If you have any questions or comments, please, put them below. I'll be happy to answer any questions you have. Okay, take care. Bye.